very possible that Denise Williams will get a new trial, and I'll tell you why. When I watched the trial, and I considered all of the evidence that was presented by the state and the defense evidence as well, I can tell you that I have no doubt. I think the state met its burden beyond a reasonable doubt, and I think that Denise Williams should have been found guilty. However, during the closing argument, the state did not play fair. At one moment, the prosecutor, John Fuchs, made an improper comment, a comment that is recognized as improper by federal courts and Florida courts as well, including the Florida Supreme Court. So here's what he said. This was towards the end of the rebuttal part of the argument, closing argument. So in closing arguments, the state goes first, and here the prosecutor did a very short first part of the closing argument, basically, I guess, saving all of his comments or argument for the second part of his argument. The defense went next, and then the prosecutor got the final word. And during that time, during the second part of his closing argument, final part, the prosecutor commented on the behavior of Denise Williams during the trial. And that is clearly improper, and I'll get to the legal part of that. Let me first read to you exactly, at least as I understood it, as I listened to it and transcribed it myself, what the prosecutor said that was improper. So at this point in the closing argument, he had just finished discussing the fact that while friends and family were searching for Mike Williams and his body in Lake Seminole, a mere 19 days after he disappeared, Denise Williams submitted paperwork to one of the life insurance companies applying for the benefits, for the $1,250,000 in benefits that she had with that one life insurance company. So the prosecutor had just finished saying that, and this is what he said. Now I'm going to quote, 19 whole days. That's a cold individual. That's a person that is involved in a homicide. Ladies and gentlemen, as I said, I was thanking you for the way you paid attention not only to the evidence presented, but to things that happened in the courtroom. Think back 3 days ago. Brian Winchester is on the stand describing how he shot his best friend, how he circled around the stump, approached 3 feet away, shot him in the face. Everybody in this entire room was moved by that and the sheer horror of that situation, except one person. That one person sat here and listened to Brian Winchester describe how he had shot and killed her husband, the man she supposedly loved and cherished. Absolute stone face. Did not bat an eye. Did not shed one tear. Use your life skills, your experience, your education. How does that apply in all of this? End of quote. So that right there is an improper argument. The Florida Supreme Court said as much in Pope versus Wainwright, a 1986 case, the citation for which is 496 Southern 2nd 798. And the court cited in a footnote where it said that those type of commentaries by prosecutors are improper to several cases from federal courts. In that case, the prosecutor had made a comment to the jurors during closing argument about the behavior of the defendant during the trial, during the testimony of a witness. And he said, I don't know if you saw it, but I saw it. The defendant, Pope, was grinning from ear to ear. This is supposed to be a wrongfully accused man, grinning from ear to ear. I don't know why he grins from ear to ear. That's all he said. So what the Florida Supreme Court says that this type of comments about the defendant's demeanor off the witness stand are clearly improper. The court cited two, like I said, federal cases for that proposition, and specifically the United States versus Pearson out of the 11th Circuit Court of Appeals, 1984. The citation is 746 F. 2nd 787, and the holding of that case was described as follows: the defendant's behavior off witness stand is not evidence subject to comment by prosecutor during closing argument. And also United States versus Wright out of the DC Circuit in 1973, citation 489 F. 2nd 1181. And the holding for that case was described by the Florida Supreme Court as follows: improper for the prosecutor to comment on defendant's courtroom behavior off witness stand. So, clearly, the prosecutor acted improperly during closing argument. He definitely referred to the behavior of Denise Williams during the trial in his closing argument. So, trying to convince the jury that they should conclude that she was a cold-blooded killer. I definitely do not think that he needed to go there at all. I think that there's super strong evidence against Denise Williams, and I will describe it in another video. But I think that there's a chance now that because of that, the defendant's motion for a new trial and motion to interview the jurors that was filed after the Denise Williams was found guilty may be granted. They filed a motion for a new trial. Here's the front page of it. And the main argument is that the verdict was against the weight of the evidence, and I can tell you that I disagree with that wholeheartedly. However, I do agree with their argument about the improper arguments and comments made by the prosecutor regarding the behavior of the defendant. As a defense lawyer, the job of a defense lawyer is to make sure that the prosecutor does not become the bully, does not violate the rules, and fairly prosecutes the case. Those arguments were improper. They also filed a separate motion to interview the male jurors who served on that jury. And they attach a copy of an article from the Tallahassee Democrat in which, this is Exhibit A to the motion for juror interviews. I'm not going to show the name of the jurors. Motion and Exhibit 8, which is an article from the Tallahassee Democrat. And the title of it is Juror Brian Winchester's testimony was credible, which, by the way, I totally agree with. And then it says Denise Williams' demeanor a factor. So, bottom line is, prosecutors messed up. Although there wasn't a contemporaneous objection, it may be close enough to be fundamental error, and even if not, it was raised immediately after the trial and a motion for new trial. So it's probably preserved, and probably sufficiently preserved, and I think that the trial court, to be fair, should grant a new trial. Although, like I said, I think the result will be the same. It should be done in a fair trial, not one that is tainted by improper closing argument. That's all for this video. Thank you, and I hope that you'll subscribe and you hear more commentary from me about the Denise Williams case and about other legal issues.